So, who is going to be opening the case this morning? I can't, now I can see you. Yes, Mr. Jaffe, yes.
I'm here with Mr. Lucas and Mr. Savassi for the first element, Mrs. Hoareau, and for the second element, there's quite a lot of people.
Right, Mr. Jaffe, hold on a second. We've got a problem here because we're live streaming at the same time, and there's a problem with noise coming out of the live streaming and on my laptop. I'm not sure I can hear that.
Can you turn the sound up at all?
How do I do that?
So just how you would normally turn it. Could you turn the sound up normally? Yeah, okay.
This is what we should sort it out beforehand.
Yes. If you go along just to the bottom, if you click the one next to it, just pull the screen across there.
Yeah.
That should help. Now try that.
Right, let's try again. Can you carry on, Mr. Jaffe, please?
Yes, I hope the feedback's been sorted. The second element, Mrs. Banku, is represented by Ms. Kaufman, Mr. Harris and Professor Hoareau. And finally, with the Secretary of State, Mr. James Eby, Mr. Beale, Mr. Bethel and Ms. Webb. Is the feedback now been sorted out?
It seems to be all right at the moment. Thank you.
Whether your lordships are working electronically or on paper, hopefully your lordships have a core appeal bundle, which is 1 lead branch file and is printed. There's a supplemental bundle, which is 2 lead branch files if you're working in physical form. And the authorities bundles are also split into core and supplemental bundles. There's 2 core authorities bundles and 3 supplemental ones. And there's also, again, an electronic version available. There are a couple of short additions to the bundles, but I think we can deal with those when we get to them. And I think if your lordships are working physically, I think copies may have already been added as the additional documents. The court has also separately received short confidentiality rings, Captain Hopkins. And as your lordships know, there is a council-only confidentiality ring for a small number of documents. What the parties have agreed in the circumstances is that it's probably not going to be necessary to make submissions of confidentiality material orally, but the parties may want to make some short written observations in reply after the hearing, and a timetable has already been set for that by Justice Dingemans. And then finally, before I turn to the substance of the appeal, Lord Justice Dingemans last week made a reporting restriction, which I think I probably ought to mention, that there should be no reporting of anything which has been said in court for at least 3 minutes, and that restriction is automatically extended in the event of any objection until the objection is put by the court. And that's just to ensure that if anyone has any concerns about mistaken references to confidentiality with documents, there won't be any reporting until that issue has been sorted out. So any members of the public watching the live stream ought to be aware of that reporting restriction. My lords, the structure of the argument on the appeal is that, first of all, the appellants have divided the issues between them in order to avoid any repetition. I'm, with your lordship's permission, going to deal with the convention claim, which is ground 2, which is pursued by both appellants. And the landscape of the argument on that ground of appeal has been significantly altered since the Divisional Court's judgment as a result of the advisory opinion of the International Court of Justice on the Chagos Islands. The other topic, which I will deal with much more briefly, is the support package ground for appeal. Now, that challenge to the support package is only made by Mrs. Hoareau. Mr. Banku does not make the same point. He doesn't oppose the submissions, but as a matter of principle, he wishes to focus on the principal issue of the right of abode and resettlement, rather than the, perhaps I can call it, consolation prize of the support package. And that leaves ground 1, which is the intensity of review issue, which is going to be dealt with by Ms. Kaufman. I propose to say funded challenge. Secondly, I'm not going to open the facts, but can I just identify a few points in the chronology which are particularly important to the convention arguments which I'm dealing with? And then thirdly, I just have three introductory points which are common themes across all the grounds of appeal. So, if I may start with the decision under challenge, as my lordship will see from the decision below, the decision was taken in November 2016, so 3.5 years ago now, and it's quoting in full in the Divisional Court's judgment, which is probably the best place to take it from. That's in the core volume appeal, tab 21, which is electronically. It starts at page 187, and the relevant extract is on page 194. All the page references are given in the electronic tabulation, which are the largest numbers at the bottom of the page.
Yes.
So, picking it up from the quote in paragraph 34, at the bottom of page 194, your lordships will see the announcement that the government decided against resettlement of the Chagosian people to the British Imperial territory on the grounds of feasibility, defence and security interest, and costs of the British taxpayer and the practicalities. That's the first element of the decision, not to provide any financial or material support for the resettlement of Chagosians to the territory. The second element of the decision is the government decided it would not lift the existing legal bar on the return of any Chagosians to the territory. And the government made that clear in response to questions that were asked by parliamentarians, that their decision was not simply about support for resettlement, but it was that no resettlement would be permitted. And that's clear from the extract at the bottom of page 195, quoted in paragraph 35 of the Court's judgment. There's a question from a member of Parliament, and then the response from the Minister is at the top of page 196 about whether someone can simply go to the island it would be illegal, given our decision that there should not be resettlement or repopulation on the island. The third element of the decision, my lords, is that the government would provide what's been called a support package over 10 years to the Chagosians, and it would have a value of approximately £40 million. That's dealt with again on page 195, middle paragraph, quote, the support package of approximately 10 years, and there's an explanation of what that package is intended to cover. And then the final, fourth element of the decision is that the exchange of notes with the United States
A moment.
Sorry, Mr. Jaffe, which page number?
Tab 3, page 21.
Thank you.
The
Thank you.
relevant provision is section 4 on page 22. Section 4.1 provides that no person shall enter the territory or being present in the territory remain there unless he is in possession of a permit under section 6 or his name is endorsed on a permit under section 8. And then the exception for Chagosians is section 4.3, except in respect to his entry into or his remaining in Diego Garcia, closed. This section does not apply to any person who is British dependent territory citizen and is such citizen by virtue of his connection with the territory. And a connection with the territory is defined in subsection 4, which is at the top of page 23. Has a connection with the territory if and only if either of the following conditions is satisfied. And the first condition is that the person or one of his parents or one of his grandparents was born in Chagos Islands, or the commissioner has given a certification that the person has a connection with the territory. So what that is it's effectively belongers legislation of the kind that one sees in many overseas territories, that if a person is born there or one of their parents or grandparents is born there, they were entitled to return there. They were not permitted to return to Diego Garcia because that was the government balancing the defence interests of one of the islands against the interests of the Chagosians. So that was 2000. Then that right was removed in 2004, possibly in large part because the Chagosians were discussing and making plans to lawfully exercise it by travelling to the outer islands. And that's discussed in Lord Manderson's judgment in Banquet number 2. But the order removing the rights is the Constitution Order 2004. That order is in the authorities bundle. It's still the core bundle at tab 4, page 31. And then section 9 at page 33 provides that no person has the right to vote in territory. And then 9.2, no person is entitled to enter or be present in the territory except as authorised by or under this order or some other law.
I'm so sorry. I'm so sorry. Which section was that?
Sorry, my lord, that's section 9 on page
9.
33.
Yes, thank you.
And the other law which accompanies it is tab 5, which is 2004 immigration order. That document starts on page 37. And on page 38, section 5 of that order provides that no person shall enter the territory or be present unless he is in possession of a permit issued under section 7 or endorsed on a permit under section 9. So that effectively restores the position in 1971 and removes the right of the Chagosians to enter any of the islands, including the outer islands. And the purpose and effect of those provisions was to deprive Chagosians of their right of abode in the territory. Now, those are the orders that were challenged in Banquet number 2. And as my lords know, that case was decided in October 2008 by the House of Lords, and the claim failed. Banquet number 2 is important to this litigation, both for the right of abode argument and also for the convention arguments. The next thing which happened, and if I could invite my lords to put away the core authorities bundle and to go back to the chronology core bundle at page 159. Chagos Islands in the United Kingdom case. So just to place that in chronology, that is the Strasbourg challenge, which followed Banku number 2. So Banku number 2 in Strasbourg. The next thing which is relevant, which happened, is Banku number 4 in June 2016. And that's in the chronology at page 166. About 2/3 of the way down the page. That's the application in the Supreme Court to reopen Banku number 2 based on alleged non-disclosure by the Secretary of State. And it was unsuccessful by the traditional bare majority by which Banku cases are decided in the Supreme Court. That decision has particular relevance to the right of abode issues, which this council is going to deal with. And then the last two dates, for my purposes, are not in the chronology, but it's the Divisional Court's judgment, which was handed down on the 8th of February last year, and then the International Court of Justice's advisory opinion, which was hot on heels, delivered 2 or 3 weeks later on the 25th of February 2019. So the Divisional Court did not have the benefits of the International Court of Justice's advisory. It is traditional at this point to give the court some verbal prose about the history of what happened to the Chagosian people. I'm not going to do that. It's set out in the judgment below, and it's also set out in Banku number 2, and I'm not going to repeat it. But there are 3 points which I would want to make before turning to the convention arguments. The first one is about the legal status of the islands. The second one is about the situation of the islands today. And third, to identify the differences in the position of the Mauritius Chagosians, like Mr. Banku, and the Seychelles Chagosians, like Mrs. Hoareau, to explain why they are separately represented and why the arguments are slightly different. As to the current legal status of the islands, the British Indian Ocean Territory is a colony in the most traditional sense. What I mean by that is that the people of the islands don't happen to enjoy any form of self-determination. And under the 2004 Constitution, the territory is subject to the direct rule of a commissioner, who is a Foreign Office civil servant, who acts solely on the instructions of the Secretary of State and has full legislative and executive authority. And so the powers of the commissioner are very different from those which are seen on the executive body in the United Kingdom. And the extent of the powers of the commissioner is not just an executive role, but it includes the power to make laws and also a power to disapply or dispense with laws. And the provision I rely on for the support of that is the 1983 Court's Ordinance in the territory. And I can just show that briefly to the court. That's in the core authorities of tab 2, page 8. And if I can pick up in the court ordinance, section 4 on page 9. Well, before I get there, I should probably ask my, sorry, I should ask you to turn to section 3 on page 8. The law in England is copied across into the British Indian Ocean Territory, subject to, and so far as it's not inconsistent with specific law, and it may be adapted to suit the local circumstances. So that's a provision which one sees in many overseas territories, providing a system of law off the shelf. But the unusual power is the power in section 4 on page 9, that the Commissioner may declare that any UK enactment, statutory instrument, or one of the Council, other than certain specified provisions, does or does not form part of the law of the territory, and that is conclusive. Now, the purpose of that provision is to reverse the effect of Article 1 of the Bill of Rights, that the power of the executive to dispense with the laws is abolished. Now, the courts, of course, give of fair balance which arise under the Convention, and also the intensity of review issues which will be dealt with by this outcome. The second introductory point I'm going to make is about the islands today. There is still, of course, the US and UK base on Diego Garcia, which has a population understood to be thousands. Diego Garcia is around 100 miles to the south of the so-called outer islands, which are themselves actually slightly less remote. They're about 300 miles or a couple of days sailing on the waters. The outer islands, but not Diego Garcia, are Mauritius. The main visitors to the outer islands are large numbers of illegal fishermen, along with yachtsmen and scientists. Then, thirdly, the position of the Seychelles Islands. Mrs. Hoareau is a good example of them. She was born on Diego Garcia, as were both her mother and both her mother's parents, and she married and had her first 3 children on the islands. Her witness statement is in the bundle, I don't need to turn it up, but for your lordship's note, it's in supplemental volume 2, page 670. Initially, she was moved to Peros Banos, one of the outer islands, and then she was required in 1973 to leave the island altogether, and she moved to the Seychelles. Now, Chagosian litigation to date has mainly been brought by Chagosians who were removed to Mauritius, and they suffered equally in their removal and the loss of their homes. But the difference which exists between them is that Mrs. Hoareau and others in the Seychelles were never compensated to any extent. An agreement was reached for a pretty modest, it must be said, amount of compensation with the Mauritius government that was distributed to the Mauritian Chagosians. But no such agreement, essentially for political reasons, was reached with the Seychelles Chagosians, mainly because the government of the Seychelles was not interested in providing this support. The history of that difference is described in some detail in the judgment of Mr. Justice claim that was brought by the Chagosians. We don't need to, I think, go through it, but if your lordships want a reference, it's Core Authorities, tab 12, page 327, paragraph 254, where Mr. Justice Usually explained those differences. And that's why the support package point is pursued by the Seychelles Chagosians. The context in which the support package issue arises is one in which their equal need for assistance with the Mauritian Chagosians has historically never been addressed. That's why that point is. So, panels, with those introductory points in mind, can I turn to the ground of appeal under the Convention? In order to succeed on this issue, the appellant needs to make good 4 points. And each of those 4 points are hurdles, so they have to succeed on each of them. First of all, that the British Indian Ocean Territory is within the jurisdiction of the European Convention on Human Rights. Secondly, that the appellants are victims under Section 7 of the Human Rights Act. Thirdly, that there's been interference with the substantive rights in Article 8 or Article 1 of the First Protocol. And then finally, that there's been a breach of those substantive rights. The Divisional Court answered no to the first 3 questions. There's no jurisdiction, not victims, and Article 8 and Article 1 of the First Protocol are not engaged. The Divisional Court did not address the 4th point because they didn't get reached. In brief outline, the appellant's positions are, first of all, that the decision not to permit or support resettlement or restore the right of abode is within the jurisdiction of the Convention. And it is within the jurisdiction of the Convention under Article 1 of the Convention. Why do the appellants say that? Well, the answer is for the same reason as conduct is within jurisdiction when a convention state has practical control of territory. The United Kingdom is in direct control of the territory and its laws, and if Mrs. Hoareau sought to go to the British Indian Ocean Territory to exercise what she says rights to a home and property, she would inevitably be arrested. Such breach of the immigration provisions that to look at. And if the UK is in effective control of territory, it is required to secure convention rights. It doesn't matter if a independent local administration has been put in place, and there is no principal difference between a UK military base in Afghanistan or occupied Iraq or the British Indian Ocean Territory in terms of UK control and therefore the duty to secure convention rights. Now, the Divisional Court's response to that was that because firearms is overseas territory, a notification under Article 56 of the Convention was the only means by which convention jurisdiction could be established there. However strong the practical control being exercised over the territory. Now, it is that analysis that the appellants say does not survive the advisory opinion of the International Court of Justice, which of course the Divisional Court didn't have the benefit of. Article 56, the appellants say, can only be relevant where the United Kingdom is properly and lawfully in international law responsible for the international relations of the territory. It cannot apply, we say, to a case where the state is unlawfully administering the territory. And the reason for that is because both the Convention, which is of course an international treaty, and international law more generally, will no longer recognise the continuing unlawful administration of the territory by the United Kingdom. It will be treated, for the purposes of the Convention and international law, like any other unlawful administration of territory, such as that, for example, of the Turkish Republic of Northern Cyprus, which the Strasbourg Court has simply consistently ignored because it is unlawful international. Now, that isn't a novel point. It's exactly the same analysis, as I've said, has been adopted in the Turkish Republic of Northern Cyprus cases by the Strasbourg Court, and it's also the same analysis as was adopted by the Court of Justice of the European Union in its recent Western Sahara case. And that will be important for my laws to look at because it gives the same effect to an advisory opinion of the International Court of Justice in relation to Western Sahara as the appellants mentioned in here. And what the Court of Justice did is they read words of an international agreement consistently with the advisory opinion to ensure that unlawful continued administration of territory is not recognised by the Luxembourg Court. So that's the first and basic argument of jurisdiction. Even if that's wrong, the appellants admit that the Divisional Court's analysis is incorrect, even without the ICJ's opinion. The reason for that is that Article 1 of the Convention and Article 56 of the Convention are independent means of establishing jurisdiction. Either is sufficient. And just looking at it practically, if jurisdiction over a breach of the Convention could not be established on the basis of control under Article 1, then the UK overseas territory would be, for example, the only place in the world where the United Kingdom could run a secret prison or commit a breach of Article 3 without breaching the Convention. It would mean there would be a grave lacuna in the protection offered by the Convention, even when the United Kingdom was in effect in practical control of the territory. So that's the outline of the arguments on the jurisdiction issue. If the claimants are successful on that, that leads on to the victim question, where again the submission is that the analysis of the Divisional Court doesn't survive in light of the advisory opinion, which makes clear that the continued exclusion of Chagos Islands from the territory is a human rights issue, and it's an ongoing issue rather than a historical issue, as the Divisional Court found. Thirdly, that there's interference with convention rights.
Mr. Duffy, can I just ask you before you go on, is that proposition something you draw from paragraph 181 of the opinion?
My lord, yes. I'm going to go to that. I'm afraid we're going to have to look at the
save my questions for then.
I'm happy to deal with it now if that's something you do.
No, not at all. I'll let you deal with it in order.
I'm going through pretty much next. Then on victim, I've dealt with victim status, and then on interference, the Divisional Court concluded that there was no longer any right to a home which was being interfered with, nor were there any property rights. And we submit that was incorrect, because we're not talking here about rights to land or personal property under English law. The Convention case law goes much further and considerably wider and recognises customary and common rights and the interests of the Chagosians in simply being allowed to be on the islands. And the Convention case law also recognises that where a person's ability to exercise their right has been prevented from being exercised, even a very long delay, measured in decades, does not prevent those rights from existing. And I'll take you to cases from in support of that. Then finally, there's a question of breach. There isn't any attempt in my learned friend Skeleton to defend the compatibility of the decision on the basis of there being no breach, and that's because the firm view of the Secretary of State is that there are no convention rights which exist. They can their hat on the jurisdictional and victim status and interference arguments. And the Divisional Court took the same approach. What I'll simply submit is that if I get past the first three hurdles, the decision is going to have to be reconsidered by the Secretary of State. So, dealing with the jurisdiction argument first. Before I turn to the ICJ advisory opinion, I've got to mention first the issue of precedent, because what the Divisional Court said is that regardless of whether these arguments are right or wrong, Banku number 2 is binding, and if it's binding on the Divisional Court, it's equally binding on this court. The proper approach then is set out, and I don't think I need to turn it up, by the House of Lords in Kay and Lambeth. Kay and Lambeth is in the Core Authorities Bundle, tab 15, page 332. And the classic statement of principle is Lord Bingham's judgment at paragraph 43. And the principle is well established that first of all the court should follow the ordinary domestic rules of precedent, but the domestic binding authority is inconsistent or possibly inconsistent with Strasbourg authority. The court may, if it wishes, express its own views and then give permission to appeal as appropriate. And for the reasons outlined, the Court of Appeal here is not bound by Banku number 2 in light of the reasoning in Alscaning in the Grand Chamber and its application by the Supreme Court in Smith. But if I'm wrong about that, then what I invite you to do is to express your opinions and to give leave to appeal, or permission to appeal, if you think that's appropriate. Turning then, if I may, to the advisory opinion, and I'll deal with it first, if I may, because it marks the most significant change since the Divisional Court gave judgment. It's in Core Authorities, Volume 2, tab 6, page 1679.
Which tab number again?
So tab 36 in Volume 2 of the Core Authorities.
Mr. Jaffe, can I just ask this question? Mr. Jaffe, it's giving advice to whom in particular? The Security Council, the whole of the United Nations? Who is the advice to?
To the General Assembly. And then as the International Court of Justice explained, and I'll show you my notes about it, the Court of Justice then explained that it is for the General Assembly, in certain respects, to decide what the consequences are of the advisory opinion and what to do about it. And the General Assembly has now indeed spoken on that issue, and I will show my Lords of General Assembly resolutions following this advisory opinion. My Lord is quite right to raise that, because it's important to look at this advisory opinion in the context of what is being requested by the General Assembly and what the General Assembly's responsibilities are in relation to the following.
Thank you.
The sole dissent of Judge Donoghue was only on the question of whether the court should have accepted the request to give the opinion as a matter of discretion. She made no comment on the correctness of the analysis on the merits. So there is no judgment, even a dissenting judgment, which suggests that the court's analysis on the merits of the advice it gave was correct. It is quite unusual for there to be such wide-ranging consensus among the jurists of international law on an issue like this. The two questions that were referred by the General Assembly are on page 1688. The first question is the question of whether decolonisation was lawfully completed when Mauritius was granted independence in 1968. So that's a question about the past, not the present. The second question, is there a question about the present? What are the consequences under international law of United Kingdom's continued administration of the islands, including the inability of Mauritius to implement resettlement of the islands, nationals, in particular those of Chagos origin. So, two obvious points about the second question. It is about the present rather than the past, and the resettlement of Mauritian Chagosians is squarely raised. The oral submissions are recorded at page 1690 from 1691 onwards. There is a galaxy of solid international law talent employed by everyone. The court then rejected challenges to its jurisdiction and decided that as a matter of discretion, it would exercise its discretion to give an advisory. The UK's argument was rejected as the court was in effect being asked to decide a bilateral dispute about sovereignty, which had been referred to the court without the consent of the United Kingdom. The court's response to that argument, I think that is worth looking at, page 1703, that's paragraph 86. The court says that the questions put to it relate to the decolonisation of Mauritius, and the General Assembly has not sought the court's opinion to resolve a territorial dispute between the two states. Rather, the purpose of the request is for the General Assembly to pursue the court's assistance so that it may be guided in discharging its functions relating to the decolonisation of Mauritius. That's one of the points which my author raised a video a moment ago. We'll see how it is developed and resolved at the moment. Then at paragraph 88, the court refers to its own advisory opinion in the Western Sahara case and the Palestinian war case, where very similar points were made and rejected. Paragraph 89, picking up the fourth line down, the fact that the court may have to pronounce on legal issues on which divergent views have been expressed by Mauritius and the UK doesn't mean that it's replying to the request for review by national disputes. So just because the court is resolving disagreements as to international law between parties here before it doesn't make it by national disputes.
Can I ask a question? Did you say the duty was owed to that the court has found was breached? The two questions concern the bilateral relationship. There's not a bilateral dispute and the court has accepted jurisdiction. It's essentially a conclusion that we were in breach of our duty towards Mauritius in the context of decolonisation. I know that doesn't necessarily exclude considering who is resident within Mauritius and the Chagos Islands. The essential two questions concerns that bilateral relationship.
Yes, that's correct. The facts are set out in paragraph 95. We don't need to go through them because they're familiar to the board. Below in independence. But the basic fact in paragraphs 95 and 96 was that the British Indian Ocean Territory should be detached from Mauritius. UK did this knowing it would lead to criticism, and the aim was for the island to be free of civilian inhabitants. There's then a detailed account of the negotiations that took place in the 1960s, and then the situation of the Chagos Islands is described from paragraph 113 onwards, and an explanation of that is then set out for the islands. And the UK's position is recorded in paragraph 116, page 1710. The UK reiterated that it fully accepts the manner in which the Chagos Islands were removed, the way they were treated. It was shameful and wrong to regret that. Then 117 is the initial payment to the Mauritian government, and then 119 there were further negotiations, and then 120 there was a further payment again paid to Mauritian Chagos Islands. The litigation which has taken place in England and Wales is then set out in detail from paragraph 131. Paragraph 131. Then turning to what the International Court of Justice decided in its final opinion, it started by dealing with the key provision of international law, which are the provisions of the UN Charter. And the critical provision is Article 73, which is quoted at paragraph 146 on page 1716. So, respect for the principle of equal rights and self-determination of peoples is one of the purposes of the UN, that's Article 1, paragraph 2, and then such a purpose concerns in particular the declaration regarding non-self-governed territories, since members of the UN which have or assume responsibility for the administration of territories whose peoples have not yet attained a full measure of self-government are obliged to develop self-government for those peoples So that is the duty on colonial powers such as the United Kingdom to develop the self-government of peoples who are under administration. And that's explained in paragraph 147. And the first question the court had to consider is set out at 148, which is really, when did that right of self-determination crystallise into a rule of customary international law that was binding on all states? I don't think anyone doubts that as of today it is such a right, but it was disputed by the UK whether it was such a right in 1965. So the court goes through the history and the opinion of jurists on that issue. And then if I could just draw particular attention to the top of page 1718, where the court quotes General Assembly Resolution 1514. As the quote says, any attempt aimed at partial or total disruption of the national unity and territorial integrity of the country is incompatible with the purposes and principles of the Charter of the UN. So the point that's being made by the General Assembly there is that the practice of partition or the division of colonies to maintain part of it as overseas territory is being much deprecated. So in light of all that material, the court's conclusion is at 160 on page 1790. The conclusion of the court is in pretty emphatic terms. The detachment of a part of the non-self-governing territory, unless it's based on the genuine acceptance of the peoples involved, is prohibited. Now, the United Kingdom's response to that was that Mauritius did consent, or the representatives of Mauritius at the time it was still a colony, did consent Now, those words used are quite important. Continued administration is a wrongful act entailing the international responsibility of that state, so the United Kingdom. That is a well-known form of words in international law, and as I'll seek to show the court in a moment, it has a particular meaning. What the court is making clear is not just that the United Kingdom's actions are wrongful in international law, but also that the principles of state responsibility apply. And that is important because it triggers obligations on other states and international bodies, including the Convention and the Court under the Convention on the Equal of Human Rights, to respond and not to recognise or give effect to the wrongful conduct. And that is the point which is made by the Court in paragraph 180. I'll come back to 179 because I know that my Lord Justice Green asked about it a moment ago. But paragraph 180, since the right, respect to the right to self-determination, obligation over honours, all states have a legal interest in protecting that right, while it's for the General Assembly to pronounce on the modalities required to ensure the completion of decolonisation of Mauritius, all member states must cooperate with them to put those modalities into effect. Then relevant principles are cited in Resolution 265. Now, that's important because it's a triggering of the obligation on other states subject to the response of the General Assembly. And then going back to paragraph 179, the court explains that the modalities necessary for ensuring the completion of decolonisation of Mauritius fall within the remit of the General Assembly and the exercise of its functions related to decolonisation. And as the court has said in the past, it's not for it to determine what step the General Assembly may wish to take after receiving the court's opinion or what effect that opinion may have in relation to those steps. So it's very important to look at what the General Assembly's response is to the advisory opinion, as well as to the advisory opinion itself. Then the court's conclusions from 181 and 182. At 181, the court deals with the resettlement issue. As regards the resettlement of Mauritian nationals, including those of Chagosian origin, this is an issue related to the protection of human rights and those concerned, which should be addressed by the General Assembly. And then, in answer to the question, from the third line, the court concludes the UK has an obligation to bring to an end its administration of the archipelago as rapidly as possible, and that all member states must cooperate with the United Nations to complete that process.
Mr. Jack, can I just suggest the reason I referred to paragraph 181 was in the context of your reference to Chagos being in a different position. And I noted in paragraph 181 that the court refers only to both Chagosians of Mauritian nationality. And I read that paragraph as essentially saying the human rights implications of all of this are for the General Assembly. I can see how obviously the judgment has an impact upon that, but it was a slightly odd way of describing the impact on individuals if it were not simply a case between two states which the court was opining upon. Now, I can see there are implications which may flow from that analysis, but it was the reference to all Mauritian nationals which I was really drawing your attention to.
Yes. Well, the first point is that it does relate to the protection of human rights. And so what the court is doing there is indicating that this is not simply a bilateral dispute at the state-to-state level. There are issues of human rights which are raised, which are properly for the General Assembly to consider to decide what to do about. And of course, whilst the court was dealing with the question of resettlement for Mauritian nationals, it certainly wasn't saying anything about what the position of Seychelles Chagos Islands ought to be. And I don't think there's any view that's ever been expressed, for example, by the Mauritian government, that if there were to be a process of decolonisation, that Seychelles Chagos Islands would be excluded from that. But of course, that would be a matter first for the General Assembly and second for the Mauritian government, which of course.
On that analysis, I think you accept that the opinion itself is not really expressing a direct conclusion about human rights issues or compensation issues, but it is recognising that's a matter for the General Assembly to address itself.
slightly further than my thoughts put it to me.
Mr. Jaffe, can I ask, I think what must be a very simplistic question, but I want to try to place this advisory opinion in the general context of the claims being made in these proceedings. Now, the substance of the advisory opinion is that the Chagos archipelago was wrongly carved out when independence was granted to Mauritius. And as I understand the opinion, it says that, well, you've got to restore the archipelago to part of Mauritius sovereignty, if you like to call it, or whatever you like to call it, in order to complete the decolonisation. And therefore the UK administration must be brought to an end as quickly as possible. But the claim of the appellants in these proceedings is for not simply restoration of their right to go back and to live wherever it may be in Diego Garcia or the outlying islands, but to go back to the Chagos Islands, but on the basis that the UK government will provide a whole lot of infrastructure and support and continuing support. I don't recall seeing in the evidence anything from Mauritius saying what it feels the support should be given to the Chagosians in their return. So I'm just trying to understand, looking at a very, very broad framework, how the essence of this advisory opinion can be reconciled with the notion that if the Chagosians, the appellants, are restored, there will be ongoing support, necessarily ongoing support and administration by the UK government.
But perhaps more fundamentally, if the opinion is correct, do we have the right at all to grant any abode status to anybody, or is that something which properly falls within the province of Mauritius?
Yeah, so the next point is, the point which my lord's putting to me, and I apologise if I'm putting it flippantly, is this is all very interesting, but why does the court care? Because the United Kingdom is, after all, a dual estate, and international law and domestic law are ordinarily separate, subject to Commonwealth defined exceptions. And my answer to that is that it is relevant to the interpretation and application of the European Convention on Human Rights. And the Convention is a regional human rights instrument contained in a multilateral treaty, given domestic effect by the Human Rights Act. And treaty obligations in general, and the Convention in particular, need to be read and operated compatibly with other obligations of international law. And so, dealing, as I am at the moment, with the question of jurisdiction, is Article 56 of the Convention, and this is the point I'll come to in a moment, is Article 56 of the Convention the exclusive route for establishing jurisdiction based on the UK's proper and legitimate control of the international relations of the archipelago in circumstances where, as a matter of international law, that administration is unlawful. So I say the proper route under the Convention, in light of the advisory opinion, is Article 1, based on practical control. And that's why I'm relying on the advisory opinion for this purpose. What my lord's putting to me is questions which come much further along the road, which is that if, for example, the court were to find there is a breach of the Convention, what should the court do about it? And is the court able to start getting involved, consistent with this advisory opinion, in granting substantive remedies that the United Kingdom government would have to deliver? Well, those raise very serious difficulties, and certainly on behalf of my client, I'm not suggesting the court has to do that. What I'm suggesting is that this decision is a decision which is unlawful, and that would have to be considered by the Secretary of State on a proper legal basis. And indeed, on the question of breach of the Convention obligations, the Secretary of State has always been essentially silent, and the Divisional Court's judgment is essentially silent on that question, no doubt recognising that those are very serious issues that might have to be considered along the road.
Well, I'm not Yeah, well, as you quite rightly said, Mr. Jaffe, you put the question back to us not in the way I put it to you. And I can understand forensically why you'd want to do that. But I think your answer to me, at any event, and it may be also to Lord Justice Green, is that true it is that the advisory opinion says that the decolonisation must be completed, and that means that I think it's implicit that the UK must cease to treat it as a separate area and cede it over to Mauritius. I mean, that must be the implication of all of this. But that, notwithstanding that, and therefore, although in the advisory opinion it's an unlawful, continuing unlawful administration by the UK, nonetheless, for the purposes of human rights and the Convention, that continuing unlawful administration still attracts human rights obligations and all that entails. Is that what it comes to?
Yes, Mark, that's right. And I'll seek to make that good by reference to some of the Strasbourg case law and also the Court of Justice's case law dealing with quite similar factual scenarios where that's been precisely the conclusion. That notwithstanding an unlawful administration of international law, where a state is in de facto effective control of an area of territory, even perhaps especially where it's being done unlawfully, convention obligations will follow to the extent that they reasonably do it.
Well, as I said, I can understand that, but that's why my question went to, I can understand that answer, which is very clear. If the consequence was simply that, for example, the wrongful administration or the wrongful occupying country or state, member state, was to desist from doing something which was contrary to human rights. But my question really was aimed at something rather different, because this is a case where what is sought is not the desisting from doing something, but positively to do something, namely to restore not just the appellants but people in a like position, and to provide all the infrastructure on a continuing basis to enable them to do so. That was my query. And I don't see at the moment, I'm waiting for the answer to say, well, how is that aspect consistent with this advisory opinion, irrespective of human rights? We're talking here about something which is a very long-term continuing obligation. That really was the essence of my question.
And that's very much a question which is directed at the question of whether there's been an interference with one of the Convention rights and the breach, if there has been an interference. So, for example, the Convention rights that are relied on, and I will come back to this in a little more detail, are, first of all, Article 8, the right to home, and Article 1, the first protocol, the right to property. And the Convention claim is not so much a claim that particular sums of money have to be dispensed by Her Majesty's government. It is a different claim. It is a claim that there is an existing and ongoing interference with existing rights to a home and property which must cease. And so it is particularly directed at the loss of the right of abode and the right to continue have the right to enter the territory and to continue exercising those rights. But I accept that if the Convention claim is framed as one of the government must write a cheque of X, then that will require particular justification under the Convention as a positive obligation. And so I accept that that's not what the Convention claim is actually directed at. It's a bit more monitoring.
Thank you.
When you say write a cheque of X, there are two cheques that might be written. One is a cheque to facilitate resettlement, and one is a cheque for compensation, because that's not possible, which may be an A1 type of claim.
It might be. And those issues could arise. That if the government is deciding that a proper fair balance is that Chagos Islands should continue to be permanently excluded, then as part of the question of fair balance, it may have to consider whether or not adequate compensation is being provided, because that might be a measure that we consider that would justify an interference. But again, that's not an issue which the government has wished to be drawn on. It is, as to date, always hung its hat on the idea that there's no jurisdiction, they're not victims, and there's not even an interference with convention rights. So we just don't need to get into the very interesting potential issues. And I understand why my lords are rightly pressing it on them, but it's quite difficult for me to answer some of them because there isn't actually a decision which addresses any of those questions. There's no decision from the government that says we consider whether or not convention rights are engaged, we accept they are, and we think this is the fair balance. Now, it's not impossible for the court to conclude that convention rights haven't been breached even though the government hasn't addressed those issues at all. That's the decision that House of Lords is misbehaving, but it is quite difficult in these kind of circumstances to see how that's to be done sensibly. And so, when it comes to the question of tailoring relief to get there, the better relief might be consideration of Washington.
Your case is essentially that if there's jurisdiction, there is at the very least the prima facie case of breach which needs to be considered.
Yes, it's proper that the government should have the first go at that, to the extent they haven't done it already, which we say they haven't. Just before I turn to kind of deal with some of those points in a little bit more detail by reference to authorities, can I just show my lords the General Assembly resolution which follows the advisory opinion, because it's obviously important because the International Court of Justice refers to the proper role of the General Assembly in responding. The General Assembly resolution is in the Supplemental Authorities, Volume 3, Tab 60. If you're working electronically, it's page 3204 in the Supplemental Authorities.
Sorry, when you say, do you say tab 60 or 6?
Sorry, 60, my lord.
60. Well, we've got, there are two, is this right? There are 2 or 3 core.
There's 2 core authorities bundles and 3 supplemental authorities bundles. It should be in the 3rd supplemental bundle, tab 60.
Right, thank you.
And my lord should have page 3204, which is General Assembly Resolution 73295. This resolution was adopted by the General Assembly, obviously after the ICJ's opinion in May 2019, so 3 or 4 months afterwards. It was adopted by a majority of 116 to 6. So it was a larger majority with less dissent than was the vote for the advisory opinion itself. And it's so important because it explains in clear terms what the General Assembly considers that international law now requires both the UK and particularly importantly other international and treaty bodies to do when it comes to the administration of territory by the UK. So I'll pick it up if I may at 3205, the second page. At the top of the page, the court records that it's received the advisory opinion and recites the court's findings. The next recital is about respecting the rule of law and an international order based on the rule of law. Reaffirms the responsibility of the UN to assist in the process of decolonisation of Mauritius. Welcomes the advisory. And then in paragraph 2, affirms the correctness of the advisory opinion of the court. What the General Assembly do is they recite each of the key findings made by the International Court of Justice and accepts them. First of all, the advisory opinion is being accepted in its total scope. And of course that wasn't necessary. It is only an advisory opinion, but the view of the General Assembly could have been that parts or all of the advisory opinion were not accepted. Paragraph 3 at the bottom of 3205
Right, I think we're in a position to carry on, Mr. Joffe.
I'm afraid I can't hear my Lord Master of the Rolls.
Oh, sorry, yeah. Yes, time to continue, thank you.
My Lords, we've just looked at the advisory opinion and the General Assembly resolution. The next issue to address is what the relationship is between the advisory opinion and obligations under the European Convention on Human Rights. And at a high level, that is explained and dealt with by the Vienna Convention on the Law of Treaties, in particular Article 31. If I could invite the Court to turn that up, that's in the Core Authorities bundle at tab 7, page 59. And the relevant provision is at page 68, Article 31. So Article 31, Sub-Article 3, sets out matters to be taken into account together with the context when interpreting treaties. And then 3C includes any relevant rules of international law applicable in the relations between the parties. And that provision is routinely cited by the Strasbourg Court as the basis on which it takes account of and gives effect to, amongst other things, advisory and General Assembly resolutions. I just heard someone in the background saying they couldn't hear. I think it's the recording of me being played back.
Yes, no, I'm not quite sure what's happening there. Just one moment while I see whether we can sort it out at this end. One moment. Right, Matthew.
So, yes.
I suspect someone may be watching the live stream with a delay, and there's a bit of feedback without their microphone on mute.
Yes, you could be right. It's important that everybody else who, other than the three judges and counsel is speaking, mutes their microphones. That is very, very important. There are 36 participants in this remote hearing, and everyone must mute their microphones unless they're either the judges or, at the moment, Mr. Jaffe. Right, carry on, Mr. Jaffe, and we'll try to see where we get to.
I'm grateful. So that's Article 31, and the leading case where the European Court of Human Rights applies that principle is the Grand Chamber decision in Demir and Turkey. And if I could ask the Court to turn that up, that's in the Supplemental Authorities bundle, tab 43, page 2221. And if you're working from the paper, it's the third Supplemental Authorities bundle. I'm sorry, I think it's tab 44, my mistake. Page 2221. My page 2221 is upside down, or partially upside down.
So is mine. So is mine.
We'll do our.
It's only the first page, I think.
It's the first page, yeah.
I think the whole report appears to be upside down, but anyway.
Yeah. If I could ask the Court, we don't need the head note, which I think certainly is upside down. If I could ask the Court to turn on to page 2241, where the Court deals with this issue of principle. Does the Court have that right way up, 2241?
Yes.
Yeah, grateful. The Court sets out, this is the Grand Chamber decision, its approach to the interpretation of convention provisions in light of other international texts and instruments. Paragraph 65, the Court explains that it's guided mainly interpretation in Articles 31 to 33 of the Vienna Convention on the Law of Treaties. And then paragraph 66, the Convention is first and foremost a system for the protection of human rights, so the Court interprets and applies it in a manner which renders rights practical and effective, not theoretical and illusory, read as a whole and interpreted to promote internal consistency. Then 67 explains its relationship with other international law. The Court has never considered the provisions of the Convention as the sole framework of reference in the interpretation of the rights and freedoms enshrined therein. On the contrary, it must take into account any relevant rules and principles of international law applicable in the relations between the contracting parties, and cites various previous decisions to that effect. And then paragraph 71, the rules of international law also include the general principles of law recognised by civilised nations. And then it explains that the preparatory works for the Convention foresaw that such principles would be applied, and it was unnecessary to insert a specific clause to this effect in the Convention. Then there's several pages of examples of the Court undertaking that process that we don't need to go through because they're just examples on their facts. But if I could ask the Court to turn on to paragraph 85 on page 2246. Paragraph 85 summarises the Court's general approach. I won't read it out because it's a longer paragraph. And in paragraph 86, it's also said it's not necessary for the respondent states to have ratified the entire collection of instruments that are applicable. The Court can look at them in any event. So,
Mr. Jaffe seems to have gone out of touch. I'll see if he can get back on again. What do you think we should do now? I think we'd better adjourn for a few minutes to see.
my Lord, can you hear me? I got thrown out, I think.
Oh, I'm sorry to hear that. Yes, you're now back fully audible, and we can see you.
I'm very sorry about that. I don't know what happened. I'm amazed it got so far. Right. So I've dealt with DMIA and the principles of international law, and those have been applied repeatedly, both by the Strasbourg Court and also by the Supreme Court in this country. One example of that, and I'm not going to take you through it, is the Supreme Court's decision in the Serdar Mohammed and Al Wahid case. Just so that you have the reference for it, it's in the Supplemental Authority, Volume 2, tab 27, at page 1219. And that is a case where it was the United Kingdom government, rather than a claimant who was seeking to rely on wider principles of international law as being incorporated and reflected in the Convention. What had happened in that case is that there was an apparent conflict between the European Convention on Human Rights and international humanitarian law, in particular the Geneva Conventions. And the European Convention on Human Rights doesn't permit internment without trial. In the absence of a derogation, can't do internment under the Convention, and that's well established. However, at a time of international or sometimes even national armed conflicts, the Geneva Conventions most certainly do permit internment, both of prisoners of war and civilians, under the Third and Fourth Geneva Conventions. And what the court did, relying on a Grand Chamber decision in a case called Hassan, was to read the Convention as permitting detention which had been authorised by other international law instruments, such as the Geneva Conventions. There was then a big issue in the case as to whether those principles ought to be extended to non-international armed conflicts that weren't covered by a treaty. And if so, how? An area where there was a big dispute in international law, but that doesn't matter. But the relevant parts of the judgment, again, I'm not going to plough through it, are page 1262 to 1263, where Lord Sumption explains the issues and the principles and how they've been applied by the Strasbourg Court. Lord Wilson, who agreed with him, makes the same points about the Vienna Convention at page 1291. So the basic point is that convention rights will be read even to the point of very substantial reading in or reading down of provisions to ensure that the convention operates compatibly with the wider body of international law. Now, none of that deals with advisory opinions, but it is also well established to rely on advisory opinions for this purpose, including advisory opinions about decolonisation and self-determination. And the best recent example of that is the Western Sahara litigation in the High Court in England and Wales, and ultimately in the Court of Justice of the European Union. I'll start, if I may, with the High Court's judgment, which is in Supplemental Authorities Volume 2, tab 24, page 1084.
Mr. Chaffee, can I go back and ask a question about this? If the General Assembly had rejected the conclusions in the advisory opinion, would the advisory opinion still have had any status in international law?
It would have had status as a persuasive statement by leading jurists in international law, but its status would be vastly reduced because the member states of the United Nations, who are each represented with a single vote on the General Assembly, would have considered and read the advisory opinion and rejected it. And if the firm view of the large majority of states is that an advisory opinion is wrong, then it's very unlikely to accurately reflect international law. But the opposite in my submission also applies. If the vast majority of states within the United Nations have reviewed and expressly accepted the correctness of an advisory opinion, that increases its weight as an accurate statement of international law.
Thank you.
So, Western Sahara, the High Court's decision is Supplemental Authorities Volume 2, tab 24, page 1084.
Yes?
So this is a decision of Mr. Justice Blake making a reference to the Court of Justice, and he finds various facts which the Court of Justice then apply. I can take most of it from the headnote. Paragraph 3 of the headnote, H3, explains that Morocco and the EU entered into two agreements. The first one about customs tariffs, and the second one about fisheries. And neither agreement distinguished between goods or fish from Morocco proper and from Western Sahara and its waters. The ICJ had previously, as long ago as 1975, produced an advisory opinion explaining that the people of Western Sahara had a right of self-determination, very similar to the ICJ advisory opinion in the Chagos case. And the key facts relating to that are set out by Mr. Justice Blake in paragraph 12 of his judgment on page 1092. First thing that Mr. Justice Blake does at paragraph 12 is he cites Resolution 1514, which we've already seen cited by the International Court of Justice in the Chagos case about the basic principle of self-determination. And then paragraph 40 on page 1093 refers to the advisory opinion of 1975. There were no ties of a nature to affect the application of the principle of decolonisation and the principle of the free and genuine expression of the will of the people of the territory. And nonetheless, Morocco had been administering the territory ever since. Mr. Justice Blake at paragraph 19 on page 1094 sets out the current status of Western Sahara, which is that the UN regards Western Sahara as a non-self-governing territory where the process of self-determination remains to be completed, and then he cites the provisions in Article 1 and Article 73 of the UN Charter, which we've already looked at. And then at paragraph 40, the court sets out its conclusions on the relevant facts. And paragraph 40 is on page 1101. Morocco claims Western Sahara as part of its sovereign territory, but the international community and the European Union doesn't recognise that claim. One of the few pieces of disputed territory where a claim by a neighbouring state's sovereignty has been examined by the ICJ, and then explains that Morocco's claim must be based on pre-existing links before 1975, a subsequent agreement with the former colonial power, military occupation, or a free act of self-determination. And then Mr. Justice Blake deals with all of those points. The first claim was rejected by the advisory opinion, so expressly relying on the advisory opinion. Second and third bases would conflict with the UN Charter in unacceptable means, and the fourth basis doesn't exist because there hasn't been any such act of self-determination. He then makes a reference to the Court of Justice on the question of how the agreements between the European Union and the Kingdom of Morocco ought to be applied in light of the status of Western Sahara in international law. And that decision on the reference is in the core authorities bundle. The court can put away the supplemental bundle. And it's in the core authorities volume 2 and tab 34, page 1586.
Right, sorry. Core authorities bundle, which tab?
34, I think.
Thank you.
Page 1586.
Thank you.
And as the court will see, this is a decision of the Grand Chamber of the Court of Justice. And the key findings, which is relevant for our purposes, is paragraph 12 of the headnote on page 1590. If Western Sahara were to be included within the scope of the association agreement, that would be contrary to rules of certain general international law applicable in relations between the EU and Morocco, namely the principle of self-determination in Article 1 and relative effect of treaties in Article 34 of the Vienna Convention. That being the case, the territory of Western Sahara was not covered by the concept of the territory of the Kingdom of Morocco. So the international agreement that the Court of Justice was construed consistent with the principle of self-determination, so as to exclude any coverage of Western Sahara. Now, one immediately sees the close similarities. There is, or principle, the finding of the Court of Justice was that nothing in the agreement with Morocco could affect Western Sahara because it would be inconsistent with the principle of self-determination. For Morocco to be making a decision on Western Saharan fisheries and tariff issues in circumstances where Western Sahara's right of self-determination had been refused.
Mr. Jackley,
Yes.
the headnote refers to paragraph 63 and 64 of the judgment. I think paragraph 62 is also relevant.
It is.
Worth noting that on Mr. Parton.
And can I ask the court to turn to it then? It's page 1664, paragraph 62.
I noted the words granted by to sovereign entities by international law.
Yes.
So which paragraph are you looking at now in the judgment?
62.
Paragraph 62 on page 1664. So paragraph 61 is the conclusion about the construction of the concept of the territory of Morocco. And the territory of the Kingdom of Morocco refers to the geographical area over which Morocco exercises the fullness of the powers granted to sovereign entity by international law, to the exclusion of other territories such as Western Sahara. So what the court has decided is that Morocco does not exercise full powers in respect of Western Sahara, or not lawfully anyway. And so therefore its ability to make an agreement binding Western Sahara was rejected. And
The point I drew from it was simply that as a matter of construction of an instrument of European law, the court was guided by what was lawful under international law.
yes, indeed, based on, as one can see, the findings of Mr. Justice Blake, which relied on the advisory opinion, which I submit authoritatively stated the position of Western Sahara, and that was how it was advanced. And that's explained, my lords, in paragraph 63 of the court's decision. If Western Sahara were to be included, that would be contrary to certain laws of general international law applicable in relations between the EU and Morocco, namely self-determination and the rest of the effect of treaties. And then they go on to make the same finding, paragraph 65 and onwards, in relation to the separate fisheries agreement, which was slightly differently worded. The wording in paragraph 65, you see, is waters falling within the sovereignty or jurisdiction. So not just sovereignty, but also jurisdiction. And then over the page, at page 1665, the same finding is made at paragraph 69. Taking account of the fact that the territory of Western Sahara doesn't form part of the territory of Morocco, waters adjacent to Western Sahara are not part of the Moroccan fishing zone. So what the Court of Justice is doing here, and it's relying on its previous authority to the same effect, one sees that in paragraph 63, is it is relying on the status of a particular territory in international law as enabling it to reach a decision as to the scope of an international law instrument. Why is the Court of Justice doing that? It is narrowing the scope of the association agreement, because if it were otherwise, the EU would be assisting or recognising a breach of the public international law right to self-determination. That's why the Court of Justice is taking that step. And we probably don't need to go through the quite lengthy Advocate General's opinion, but there is a detailed explanation of the policy reasons for exactly why the court is being invited by the Advocate General to do that, and that is the step which the court takes. So, the appellant...
This for the Advocate General's opinion for our notes.
The key paragraphs of the Advocate General's opinion, it's Advocate General Wapelet. First of all, paragraph 125, which explains the history of the right of self-determination and its status, then goes on to explain the principles of the UN Charter that we've looked at, and then 127 to 129 explains that the right which is involved is a right erga omnes. In other words, it's a right which has to be given effect by other international organisations and by states, and it's recognised as a peremptory norm. Then goes on to reach conclusions in light of that analysis as to the status of Western Sahara in international law, cites the advisory opinion, and then makes those recommendations to the court, which the court accepts. And preceding that decision, there was another decision about Western Sahara in a case called Front Polisario, which is cited repeatedly by the Advocate General of the Court, in which the court made similar findings and accepted the advisory opinion in relation to Western Sahara. So, the appellants, I think, take four propositions from that review of the authority. First of all, that the right to self-determination is a fundamental principle of international law and reflects the provisions of the UN Charter. Secondly, that it's a right which is erga omnes. In other words, it engages the interests not just of two states in a bilateral dispute, but all states and all international organisations who should not give effect to a breach of the principle of self-determination. And that applying those principles here, thirdly, the continued administration of the archipelago by the UK is a breach of that principle, because the UK is required to cease its administration of the islands, so says the International Court of Justice, as approved by the General Assembly. And then finally, both the European Court of Human Rights and applying the same principles, the Court of Justice, not because this is an EU case, but because it's a useful exposition of how a court formed under a treaty approaches other international law. The courts implementing rights granted under treaties will construe and give effect to legal obligations so as to act compatibly with the right of self-determination. And that may mean not recognising an attempt by an administering power, whether it be Morocco or the United Kingdom or whoever, to take decisions for a territory where it's wrongfully exercising its right to self-determination, wrongfully exercising its right to prevent self-determination. That what the courts have done is they've simply ignored or read instruments so as to prevent the courts giving effect to and assisting an interference with that important right to self-determination. And that's precisely what the appellant suggests is the proper approach here. So, turning to the application of those principles to this case, the Divisional Court's analysis was that the absence of a declaration under Article 56 was fatal to the jurisdiction question. And the logic behind that is that the United Kingdom could have made a declaration in respect to the British Indian Ocean Territory, but for whatever reason, it chose not to, and that was the end of that. And so, at this point, it may be useful to have a quick look at Article 56 and see how it fits into the Convention. Article 56 is in the Core Authority Bundle at tab 6. Page 53. Article 56.1, a state may declare by notification that the Convention shall, subject to paragraph 4, extend to all or any of the territories for whose international relations it's responsible. So what we need to do is we need to understand what those words mean. What does it mean to be responsible for the international relations of the territory? appellant's point is simply that responsible can only mean lawfully responsible, compatibly with international law. Otherwise, the United Kingdom will be able to make or decline to make a declaration which was completely unlawful as a matter of international law, but would be recognised by the Convention as being valid. And that's an improbable proposition of international law in our submission. So when construing the Convention, you apply Article 31.3 of the Vienna Convention, take account of any other rules of international law applicable to the relations between the parties, and it's the same issue ultimately as in Western Sahara. An international court, when deciding the interpretation of the treaty, will not construe it so as to give effect to and support a breach of international law, especially a norm of the importance of the right of self-determination, especially when that is being done to oust the human rights jurisdiction of an international treaty regime.
Well, I need to understand this. I mean, at first sight, it doesn't seem a very probable proposition that the Council of Europe, responsible for the European Convention, would have wanted to prevent a member state from extending the Convention into a state, into an area for which, whether rightly or wrongly, the member state is purporting to be responsible. I mean, that's an extension, not a confinement of the Convention. Isn't that something that would, on the face of it, be welcomed?
Well, that's almost like saying that the people of Western Sahara ought to have welcomed the opportunity to be able to sell their goods with low tariffs to the European Union. Whether or not a treaty is a benefit or a burden can be rather in the eye of the beholder. And it doesn't prevent the Convention from applying because, as I'll come to, there are two routes to the application of the Convention. One route under Article 56 by a declaration. And it's the absence of a declaration which is here being relied on by the Secretary of State. The Secretary of State is saying, I haven't made a declaration, and so therefore there is no human rights jurisdiction. Even though my decision to make or not to make a declaration is one which in international law I have no power to make. Now that doesn't prevent the Convention applying, because when the UK is in effective control of territory, then the Convention will apply as a result of Article 1. But it doesn't prevent, for example, if there is a breach of human rights, a remedy being granted under the Convention. But what it does do is it prevents interference with the right of self-determination by the administering state, which is administering a territory unlawfully in international law, making a decision which binds the territory in international law.
But you're saying it's bound anyway, by a different route.
Yes, but the argument which is put against me is that because of the existence of Article 56, and on top of the existence of Article 56, the decision of the United Kingdom not to make a notification under Article 56 in relation to the British Indian Ocean Territory, it's game over for the application of the Convention. And so in effect, because of the United Kingdom's decision not to apply Article 56 and to make a notification under Article 56, the Convention can never have any application. And I say that that decision is one which the United Kingdom is making in the unlawful administration of the British Indian Ocean Territory, and so therefore it shouldn't be recognised, and that Article 56 can't be an exclusive route in these circumstances. And the reason for that is that if that were to be accepted, the UK would be making or declining to make a declaration which is unlawful in international law because it has no power to do so. It has no power to administer the territory or to conduct its international relations, as we've seen from the advisory opinion and the General Assembly. So the UK is in effect seeking to rely on its own improper conduct, whether it's a declaration or the absence of a declaration, in order to prevent the application of the Convention. And I suggest that is what is improper. In other words, putting it another way, I suppose, you don't give the state the choice to avoid the convention by relying on its own conduct in breach of international law and its own erroneous view of whether it's lawfully allowed to administer the territory. Now, I appreciate I've already mentioned some of the Cyprus and Turkey cases where very similar issues have arisen in Strasbourg, but this might be the right point to have a quick look at one or two of them, because they may answer in particular part of my Lord the Master of Olds' questions about how this is to be approached.
Can I just make sure I understand your argument? Your argument is that the UK can't resolve from its obligations because it failed to make a deliberate choice under Article 56, because you say Article 56 can't apply. Nonetheless, what we have is a position of de facto control, even if not de jure control, and you therefore say that has to be analysed separately from the regime under Article 56.
And as I'll seek to show the court now, the way the Strasbourg court has always dealt with de facto unlawful control is through Article 1. The court has never looked at it at all through the prism of Article 56 and has always rejected arguments based on Article 56, has simply said that where you are in de facto control of the territory and your de facto control is unlawful as a matter of international law, then the court will look at the practical reality and it will say that jurisdiction exists under Article 1 of the Convention, which is a general jurisdiction provision. It's not very informative when you read it, but it makes sense in light only of the court's case law.
But I think what this comes to, and you may well be right about this, I'm not expressing any view about that whatsoever, but it seems to me where your submission comes to the end is that where under international law one country is wrongfully administering another, it is incapable of excluding the application of the convention by any means.
Where the administering state is in effective control of the territory or people on the territory.
Yes.
So that's the caveat which I add, and that caveat comes from the Article 1 case law. So it depends whether in practice the UK is in fact physically administering the territory.
Thank you.
And that's the point which I'll seek to make good by reference to the Cyprus and Turkey cases. The same points are made in most of the Cyprus and Turkey cases, but I'll do it, if I may, by reference to the Grand Chamber decisions in the Loisitouh and Turkey litigation. And there are two Grand Chamber decisions. The first one is in the Court Authority, Volume 2, tab 25, page 1079.
Just before you do that, your analysis is designed to trigger Article 1 and or Article 8 of the Convention. To what extent are you relying upon fundamental rights and common laws, which you set out in your skeleton and say that the right of self-determination is treated as a fundamental right by the judges in Bangkok?
Yes, that's right, and that's relevant to the points that Ms. Kaufman's going to be dealing with, which is whether the decision is in breach of ordinary domestic principles of judicial review. And I understand that both the appellants suggest that the right of self-determination is also a fundamental right of common law, and therefore anxious scrutiny is required. That's a proposition which the Divisional Court rejected, and which is passed the first round of appeal. But I'll leave that for Ms. Kaufman, if I may, rather than steal that. So there are two Grand Chamber decisions. The one at tab 25, page 1079, is the preliminary decision on jurisdiction. The basic background is the Cyprus and Turkey disputes, where Turkey essentially annexed Northern Cyprus and created the so-called Turkish Republic of Northern Cyprus, which was in practice, of course, a puppet regime on Turkey. The basic finding in the case is that Turkey was in effective control of the territory, so it had to secure the convention right, and jurisdiction was found under Article 1. The key passage in the Grand Chamber's decision is on page 1104, at paragraph 62 to 64. Could I invite the court to read 62 to 64 rather than read it out somehow?
Yes.
So the upshot of that decision is jurisdiction is limited to national territory. Acts of authorities outside, producing effects outside of territory, can be included, and given the object and purpose of the convention, lawful or unlawful action, military action, which leads to effective control of an area, leads to application of the convention. So that was the court's preliminary decision. The court then returned to the same issue in its substantive decision on the merits, because Turkey sought to re-argue the points and have another go. And it's worth looking at the substantive decision, which is in tab 27, starting at page 1164. Not least because the court makes a number of the points which I sought to make to your lordships this morning. So picking it up at paragraph 43, page 1164, the court cites the Vienna Convention, Article 31.3c, taking account of rules of international law. And then over the page of paragraph 44, evident from international practice and various strongly worded resolutions, which are cited above, the international community does not regard the TRNC in quotes as a state. The Republic of Cyprus has remained the sole legitimate government of Cyprus. And then against this background, the court cannot attribute legal validity for the purpose of the convention to such provisions as Article 159 of the fundamental law on which the Turkish government relies. And that's a confiscatory provision in TRNC law, which the court simply rejected the validity of. Then at paragraphs 45 and 46, there's an interesting discussion about what this means in practice for the protection of fundamental rights. So paragraph 45, the court says, you're not getting a general theory from us about the lawfulness of legislative and administrative acts of the TRNC. However, international law does recognise the legitimacy of certain arrangements and transactions, such as births, deaths, marriages, the effects of which can be ignored only to the detriment of the inhabitants of the territory. And then footnote 30 cites the Namibia and South Africa advisory opinion of the International Court of Justice. So again, one sees the Strasbourg Court taking account of an advisory opinion to decide on the scope of convention obligations directly relating to jurisdiction and the proper scope of convention jurisdiction. And what the court is saying is that where it would be to the detriment of the inhabitants of the territory, then the court may be prepared to give effect to certain acts, such as, for example, the registration of a birth or a death or a marriage by the state, the de facto state. But when it comes to the recognition of breaches of fundamental rights, such as the confiscation of property, the court won't recognise it or give effect to it. And then the conclusion is at paragraph 46. Accordingly, the applicant cannot be deemed to have lost title to her property as a result of the constitutional provision in the TRNC. So, what it comes to, my lords, is that on the Divisional Court's approach, Turkey perhaps made a mistake with the Turkish Republic of Northern Cyprus, what it should have done, if it had been properly advised, was to announce we have annexed Northern Cyprus and we hereby declare that it is an overseas territory of Turkey. And we also decline to make an Article 56 declaration. And that would have been the end of this. They would have got away with all of the breaches of the Convention in Northern Cyprus without Convention jurisdiction. And everyone's rather been missing the trick. I'm being slightly flippant, but it is a serious point. It can't sensibly be the case that when exercising unlawful jurisdiction over a territory, it makes a difference to the application of the Convention whether the state makes or doesn't make a declaration that's unlawful, that something is an overseas territory or not. And it can avoid Convention liability for a breach by calling something an overseas territory, even when its continued administration of the territory would be unlawful. A very curious result in our submission. Now, my learned friends have put forward a number of arguments on behalf of the Secretary of State as to why this analysis is wrong. And I will, if I may, deal with them. The analysis that they put forward is set out most conveniently in the respondent's notice, which is reflected in their skeleton argument. Because the respondent's notice is in the form of a list, it might be quicker to take the points from the respondent's notice. The respondent's notice is in the core volume of the appeal, moving away from the authorities, tab 6, page 36. Picking it up at the second paragraph, the respondent's notice says, in brief summary, the advisory opinion doesn't assist the appellant in her ground of appeal based on the Convention because, first of all, it's a legal opinion and is addressed to the General Assembly, not binding on the UK as a matter of international law, wrong for the English court to preempt any response from the executive to the ICJ, the General Assembly and other sovereign states. The sovereignty dispute has no bearing on the interpretation of Article 56, and the advisory opinion nowhere states that Chagosians have a human right to self-determination exercisable against the UK. The right is in the context of decolonisation for the Mauritian people. And then 4, ICJ did not say that it was breaching a peremptory norm of international law, and didn't say that other bodies such as the Court of Human Rights were obliged to withhold recognition by reason of such a breach. Well, so briefly taking those points in turn. First of all, of course, the legal opinion is addressed to the General Assembly, and of course it's not binding in international law, and of course it doesn't preempt the response of the General Assembly. But the appellants aren't preempting the view of the General Assembly. The General Assembly has now voted on it and has approved the advisory opinion's correctness and set out what the consequences should be. And including in paragraph 7 of the resolution we looked at, the consequences for international bodies, such as the treaty body under the European Convention on Human Rights. The second point that's made is that the sovereignty dispute between the UK and
Mr. Jaffe, sorry, Mr. Jaffe, sorry to interrupt. The respondent's notice talks about preempting the response from the executive rather than preempting the response of the General Assembly. Whereas
my understanding is that the UK don't agree with the advisory opinion and they don't intend to comply with it. In the same way that the Kingdom of Morocco doesn't agree with the advisory opinion and doesn't intend to comply with it. And that the Republic of Turkey doesn't agree with the European Court of Human Rights' analysis of the status of the TRNC and doesn't intend to comply with any of that court's orders. So it is, I'm sure, certainly the view, and I'm sure Sir James will be able to tell you, that the United Kingdom vigorously disagrees, having argued the points, with the advisory opinion's conclusions and thinks that its submissions were by far the better ones. But nonetheless, it's very clear that the advisory opinion does reflect international law as it currently stands. The proper role of this report, through the lens of the Convention and the Human Rights Act, is to apply international law. And it may well be that, as the International Court of Justice said, there's a dispute about what international law is, but that doesn't mean that the government's view automatically is the correct one. If we had been in the position where there was no advisory opinion, and I was simply submitting the arguments which were found to be correct by the International Court of Justice, the appellant's position in this appeal would of course be far less strong. And the reason for that is it would be my submissions versus the government's submissions. And it would be said there is no authoritative international determination of the issues of international law, still less one that has been considered by other states. But of course now we have both those things. That's why, even though I'm sure you'll be told that the advisory opinion is wrong from top to bottom, that shouldn't prevent the court from, unless the court thinks it's wrong, the court properly applying through the lens of the convention. I'm sorry, that's a very long answer to a short question, but I hope that's summarised what the appellants say about it.
Thank you.
So the second point that's made is about the sovereignty dispute. Well, it's quite right that the decision of the International Court of Justice in its advisory opinion is not about sovereignty, but about administration. And of course, they weren't seeking to resolve the sovereignty dispute. One can imagine many solutions to the ongoing sovereignty dispute between the UK and Mauritius. One solution that the UK might no doubt favour is one of continued UK sovereignty. Might not find favour with Mauritius. There are other, of course, sovereignty dispute solutions involving a split of the islands, or joint administration, or joint sovereignty. But that was no part of the ICJ's analysis, and it's no part of any of the parties' submissions before the court in this case to try and resolve that. Those are separate issues of international law which just don't advance. The third point is really very similar. They say that the ICJ's conclusion wasn't about the human right of self-determination against the United Kingdom. Well, the ICJ and the General Assembly said that the administration of the islands was unlawful, that it has to end, that it's a breach of an obligation erga omnes, and it engages the human rights of the Chagos Islands. So we don't accept that proposition. The fourth point that it's made is that the Court of Justice didn't say there was a breach of a peremptory norm. Now that's quite right. The International Court of Justice didn't say that the breach of the obligation of self-determination here was a breach of a peremptory norm. But that is completely irrelevant as a matter of international law. The relevant issue is whether there was a breach of an obligation erga omnes. In other words, an obligation which applies to all states of international organisations to recognise that a breach has occurred and to take steps not to give effect to it and bring it to an end. And of course, that's exactly what the International Court of Justice did say expressly in terms of paragraph 180. If it does genuinely matter whether or not the right of self-determination is a peremptory norm, then I'll return to that if I may in reply. I'm not a proper international lawyer, but one of the things you learn in one of your course of public international law is that self-determination is certainly on that list, and there's overwhelming authority to that effect. But if that point is seriously pursued, I'll return to it in reply rather than drag you through a bunch of other authorities to prove it. Now, another point that my learned friends make in response to the arguments is not set out in the respondent's notice, but it is set out in their skeleton arguments. Their skeleton argument is in the core volume, tab 12. If I can ask your lordship to look at paragraph 99 on page 135. The point is taken that neither of the appellants is in the United Kingdom nor in the British Indian Ocean Territory. That the first appellant is resident in Seychelles and the second appellant, Mr. Banku, is resident in Mauritius. Now, that isn't the Secretary of State's strongest points. If my house in London is confiscated by the government, it doesn't matter if I happen to be abroad on holiday when it happens. The convention jurisprudence applies a test of when interference with the right occurs. It's the location of the breach, not the location of the victim, that is important. And of course, the location of the interference of the rights here is the British Indian Ocean Territory. So if the appellants tried to return to their former homes, they would be physically prevented from doing so. Then the Secretary of State goes on at paragraph 99, over the page, on page 136, in the penultimate sentence, to say that the United Kingdom is under no legal duty to respect convention rights that third country nationals might have if they were lawfully resident within the United Kingdom. That's an interesting proposition for which no authority is cited. But if what's being suggested is that in order to have a convention right, you have to be lawfully present in the United Kingdom when the right is breached, that's obviously not correct. On that logic, an unlawful entrant to the United Kingdom would have no convention rights. And the fact that someone is abroad when their rights are breached is completely irrelevant. I mean, to give the simplest example, if the Divisional Court failed to give a fair hearing to the claimants in breach of their Article 6 rights, the fact that they happen to live in Mauritius and the Seychelles would be neither here nor there. The question is where the breach has occurred. So those are not good points in my submission. Now, the remaining point which is made, and it's the last point I need to deal with on jurisdiction, is the Secretary of State says, well, all this is very interesting, but why don't you save your breath for the Supreme Court? Because this court is bound by Banku No. 2. And so it doesn't really matter whether your analysis is right or wrong. This appeal has to be dismissed. Well, the answer to that is that, first of all, I suggest this court isn't bound by Banku No. 2 in light of later developments in Supreme Court authority. But if it is, then as I've already said, in light of Kay and Lambeth, the proper course is for this court to dismiss the appeal, but to grant, if it thinks it appropriate, permission to appeal to the Supreme Court. So, just to deal with those points, and I can probably do most of it before the short adjournment. The starting point in relation to Banku No. 2 is not that decision itself, it's actually the decision in quark fishing, because Banku No. 2 is simply an application of the judgments of quark fishing. Quark fishing is in the core authorities bundle. Volume 2, tab 29, page 1225. Just so the court has the outline of where I'm seeking to go with this. There is, first of all, the decision in quark fishing, both in the House of Lords and in Strasbourg, and I think we probably only need to look at the Strasbourg decision. And that was the basis of the reasoning in Banku No. 2. Now, quark fishing and Banku No. 2 proceeded on the basis that the UK was indeed responsible for the international relations of the relevant overseas territories within the meaning of Article 56. Now, it is that assumption which is, of course, challenged in this appeal. So, after quark fishing, which relies on that assumption, as we'll see, there was Banku No. 2 in the House of Lords, but it was just decided on the basis of an application of quark fishing. And the older cases on Article 1 jurisdiction. And again, it's decided on the basis that the UK is properly responsible for the international relations of the Chagos Islands, which, as a result of the ICJ's advisory opinion and the General Assembly's resolution, is no longer a correct assumption. Banku number 2 then became the Chagos Islands case in Strasbourg. And in that decision, and again, we'll have to briefly look at it, the Strasbourg court was very careful not to decide the jurisdiction question at all. The application was disposed of on other grounds. You'll see that. And the reason why the point was not dealt with in that case is that between Banku number 2 and the Chagos Islands decision, there was the Grand Chamber's decision in a case called Al-Skani, which marked a very significant development in the Article 1 case law.